Hey everybody, look at me, I'm the most on time that I think I have ever been. I woke up with a killer headache today. I'm here anyway, because ain't nothing gonna pull me down, nothing gonna break my stride, nothing gonna hold me down. I got to keep on moving, ain't nobody gonna break my stride. No, I gotta say, I've actually been really enjoying having like something like that's what's the word I'm looking for? It's a little bit more of a structured schedule, I guess. And so streaming every day at 2:30 has been pretty good for me. I think last week there was only one day I didn't stream. It was a Saturday, because I did end up streaming on Sunday. It was a little bit later on in the day, but we did games. So ain't nothing gonna come my stride. Nothing gonna hold me down. Anyone, welcome. I'm glad everybody's able to make it. Oh god, I can't believe we got through 47 yesterday. 47 was disgusting and the most adorable thing in this entire lawsuit. So much of it has just been like insane, either cringe or just like dumb. Just like why you do the stupid. And so it was really nice. It was really nice to see something so wholesome in seeing Ben and Steve. So cute. The links have been added to the description of those videos, so if there was anything you missed, like the hearing transcript or Kyle's deposition transcript, that is there, so you can go check those out at your own leisure. Hi, Puck. You gonna hang out under my desk? Okay, you do that. We are down to 6 days till the hearing on May 11th. So we're making pretty good progress. We're at 48. There has been another filing, so now there's 58, and it's affidavit for Steve. Steve's adding shit. God damn it, Steve. You're gonna make my life more difficult. Why? Although I did hear that Steve never had any drama before me, so before I existed. So I guess we're even. Every so often that man tags me in something, and I'm just on Twitter, and I'm just like, did I harm you in an alternate life or something, in a previous life? What have I done to you to deserve this? The moral bonfire continues. Love the circus. Feel bad for the loss of good content. The sooner we get this finished, the better. Absolutely. Between me and Steve, we have like a good number of guests that are essentially at this point, and topics that are essentially on standby. And they have to be on standby until we get NonSeq back, and I guess they don't have to be, but we don't want to burn through all of the good shit, you know what I mean? Garm for 59 sec, love the work, Chesh, have some beer on me. Oh, cheers, my friend. Blessings from our Lord and Savior, alcohol. I feel like I need more reading through this. I will give Puck a boop. Here you go, Puck. Boop. He's under the desk. He's getting his boops. Don't forget to boop that subscribe button. Madia says, my anxiety for May 11th is curbed by your everyday readings of this case. No, yeah, fair enough. Todd says being associated with him, Steve. Yeah. Oh, right. No, thank you. It's much appreciated. Reading through all of this over again has been a chore. But you know what? It's been fun, so I don't regret it. I'll probably end up, it's been nice to get on a schedule, so even once I'm done catching up reading these, I'm just gonna stick with doing goblin raids I'm gonna stick with that. 2:30, I'll be here doing something. Something will be happening. So, let's see. We are on 48, notice of filing of depositions 2/10/43 to 48, and this is submitted by Steve's lawyer. So, North Carolina, Guilford County, Steve McRae plaintiff versus Kyle Russell Curtis defendant in the General Court of Justice, Superior Court Division 19 CVS 8163, notice of filing of deposition exhibits. Plaintiff Steve McRae, through his undersigned counsel and pursuant to the court's instruction, submit this notice of filing. The following deposition exhibits, which are either audio or video files and therefore cannot be filed through electronic filing system, or sent to the court directly. Exhibits 2, 10, 34, and 38, respectfully, blah, 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 certificate of service. So that's just saying that things that aren't on the notice of filing for those numbers that we read through yesterday, they couldn't be submitted through the electronic filing, so they've been sent to the court otherwise. Okay, so now we get to the court order. This is the spicy bit. So you'll notice that the hearing happened. There was a lot of people saying that, oh, Steve's lying, Steve's going to get deposed, oh my god, Steve is fucked. But you'll notice that there was no deposition for Steve. The only people that got that were Kyle and Ben. So... you guys come to... you don't need me to tell you. You guys can come to your own conclusions about this nonsense. State of North Carolina. Although I do enjoy that people are probably going to try and argue with me or argue in the comment sections or whatever, and it's like, I'm just reading what's here. It's like, you're gonna argue with the court documents? I don't know. That seems to be the case. Whatever. State of North Carolina, Guilford County, Steve McRae plaintiff versus Kyle Russell Curtis defendant in the General Court of Justice, Superior Court Division 19 CVS 8163. Order 1. Plaintiff served the civil summons and complaint in this action on defendant Kyle Curtis on August 30th, 2019 by delivery by certified mail to what plaintiff contends was then Curtis's place of residence. See Affidavit Service of Process, ECF number 7. Curtis's mother signed a certified mail return receipt documenting delivery of those materials to her at that address. AT2 Production says people lying to push a narrative that they want to be true. That never happens. Who would do that? I don't know. On October 3rd, 2019, this court made an entry of default upon plaintiff, proof of service, and Curtis's having not timely responded, ECF number 9. Plaintiff then filed his motion for default judgment, ECF number 10. On November 19th, 2019, the court attempted to provide Curtis with notice of the motion for default judgment through its posting on the court's electronic docket and by mailing a copy to Curtis at his last known address, ECF number 16. Yeah, at one point the judge... Was it the judge that asked Kyle? Somebody had asked Kyle if they had received the court documentation. So they didn't receive what Steve had sent, but if he had received what the court had sent him. So that was interesting. Although he contends that he had not received the complaint and summons at this time, other materials of record now demonstrate that Curtis had become aware of the lawsuit having been filed against him before the court entered any default judgment. On January 23rd, 2020. So this is what the court is stating as fact in the decision the court is making after the depositions have gone through. Just in case that wasn't clear. A Boy for Two says you can only boop Puck, you can't smash him. Please do not smash my dog. He will get boops. Gentle, gentle boops. There was a joke that we used to tell. Puck likes to play with people's feet. So if, and eat your, the pant leg, like the I don't know, your sleeve where your sock is, like this part of your pants. And so he likes to wrestle, so you can push him around. Like if you sit on a couch, you can push him around with your feet and he'll play with you. He likes to play that way. So every so often, if you wanted to play with him or give him a hard time, you would just say, "I'm going to pet you swiftly once with my foot." And he would just be like, "Yes." Adorable. On January 23rd, 2020, the court entered a partial judgment by default, having received no filing by Curtis challenging either service, the entry of default, or plaintiff's motion for default judgment, ECF number 17. On February 16th, 2020, Curtis filed his motion to set aside default judgment motion, ECF number 19. Curtis thereafter amended his motion and filed multiple affidavits and documents to support his contention that he was no longer residing with his mother at the time of service, but rather living in Charlotte, North Carolina with Benjamin Potts. On July 28, 2020, among other materials, Curtis filed his own affidavit, a document purporting to be an affidavit from Potts affirming that Kyle lived with him at that time of the summons and complaint were served. A lease bearing purported signatures of both Curtis and Potts, and a Discover bank statement purportedly mailed to Curtis at Potts' home address, ECF number 2031.1. Who just brought up the knuckle puck from the Mighty Ducks? Todd, really? It's knuckle puck time. Love the Mighty Ducks. God damn it. Oh my god. Alright. On September 9th, 2020, plaintiff filed an affidavit by Potts testifying that Curtis had forged Potts' signature on both the affidavit and lease Curtis had filed in support of his motion, and that, in fact, Curtis did not live with Potts in Charlotte at that time. The complaint was served and had not paid Potts rent, ECF number 38. Plaintiff also filed evidence which he contends proves that Curtis materially altered the discovered bank statement to falsely claim that it had been mailed to and received by Curtis in Charlotte at Potts' residence. A Canadian loves a corny hockey movie. I'm shocked. Listen, you don't understand. You don't understand. I feel so attacked right now. Oh, hey, Bunny Wabbit. Curtis has contended and Potts has denied that Curtis made rental payments to Potts in July and August of 2019 through the Discover account. Having reviewed the contradicting sworn statements, the court advised counsel that it believed depositions of both Curtis and Potts should be taken. On October 22nd, 2020, transcripts of the deposition of Curtis, ECF number 47.2, and of Potts, ECF number 47.1, together with multiple exhibits were filed. See Notice of Filing, ECF number 47. Each continues to challenge the testimony of the other in material respects. Curtis testified during his deposition that he has or will soon have additional materials to support his position, but that he would only provide them to his counsel and not directly to Potts or Potts' counsel. Those documents include bank statements from Discover, original electronic files of Curtis's affidavits filed with the court, and other materials. He never filed those and still hasn't to this day. Same with those text messages that he said he had, then he said he didn't have. The ones that he used to threaten Ben with, you know what I'm talking about? Yeah, I don't know what you mean. Curtis's motion is now before the court for ruling. The court wishes to make its ruling only after being satisfied that Curtis has been given adequate opportunity to file documents he contends support his position and which the court considers potentially relevant to the court's assessment of the credibility of the competing witnesses. The court directs that Curtis shall have until 5 p.m. on November 5th, 2020 to file those additional items identified in his deposition that he at that time intended to produce or file. But for those specified materials, the court deems the record on the motion closed absent further order. Also, on October 22nd, Curtis's counsel of record filed a motion to withdraw, stating that Curtis had not yet stated his position regarding that motion, ECF number 45. Should Curtis elect to respond to the motion to withdraw, he shall do so prior to 5 p.m. on November 5th, 2020. So it is ordered the 26th day of October 2020. Hooray! Remember the 5th of November. Yeah, we had, there was a meme train going on on Twitter for that one. Will he file anything? Does he file anything? I'm not letting you guys vote this time. The answer is no, because it's just court. So here's the November, so that was on in the dockets, it's October 26th, and then the next one is November 20th. So it's almost a month later. So let's see what the court had to say. State of North Carolina, Guilford County, Stephen McCrae plaintiff versus Kyle Russell Curtis defendant in the General Court of Justice, Superior Court Division 19 CVS 8163. Order on amended motion to set aside. This matter is before the court on Kyle Russell Curtis amended motion to set aside entry of default or partial default judgment, the motion, ECF number 30. Having considered the briefs, affidavits, depositions, and other evidence submitted in support of and in opposition to the motion, arguments of counsel at a hearing held on September 16th, 2020, and relevant authorities, the court denies the motion. Denies, in all capitals. So this is Kyle saying, hey, listen, I was never served. Here's why I was never served. Court being like, nah. Nah, brah. Factual and procedural background. Plaintiff served a civil summons and complaint in this action on August 30th, 2019 by certified mail addressed to Kyle R. Curtis at 1532 Providence Church Road, Pleasant Garden, North Carolina 27313. At the Pleasant Garden address, see Affidavit Service of Process, ECF number 7. Defendant's mother, Suzanne Curtis, who resides at the Pleasant Garden address, signed a certified mail return receipt documenting am I in your way? Okay. Good boy. You going on the couch? Oh, you gonna look out the window? Is there a friend out there? A work? Don't knock over my plants. Don't do it. You know. Does the tomato plant smell good? Good boy. Yes. Okay. Now that he's settled back down. Defendant's mother, Susan Curtis, who resides at Pleasant Garden address, signed a certified mail return receipt documenting delivery of those materials to her at that address. The case was designated as a mandatory complex business case on August 23rd, 2019, ECF number 1, and assigned to the undersigned on August 26th, 2019, ECF number 2. Undersigned meaning this court and this judge. As a result, all proceedings in this matter have been publicly available through the court's website at which is the one I'm looking at. And you can go find yourselves if anybody is interested in finding it and wants to look into anything more in particular. Just search North Carolina Business Court. It will be listed under public access on Google. If you don't have access to it, sorry, this is the best I can do for you. I'm not screenshotting the whole thing. That's way too much. Please don't do that to me. On October 3rd, 2019, this court made an entry of default upon plaintiff's proof of service and Curtis having not timely responded, ECF number 9. On October 9th, 2020, plaintiff filed his motion for default, ECF number 10. Also, if you are interested in some of the things that were going on at the time that these were coming out, there is a playlist on my channel that will link you to pretty much everything every additional stream that was happening with people directly involved. I didn't bother grabbing things that were like tertiary, so it was only like direct stuff that I tried to grab. So if you want to go see that, you're welcome to go check that out. Intrigue Feline has also written a really good briefing on this. I read part 1 and part 2, so if you're interested, that also exists. On November 19th, 2019, in addition to the posting of the plaintiff's motion for default judgment on the court's electronic docket, the court mailed a copy of it to Curtis at his last known address, ECF number 16. While the letter was not certified, Curtis has not denied receiving it, and the court's letter has not been returned by Postal Service as undeliverable. Curtis has maintained that he has not received the complaint prior to the motion for default judgment being filed. He has not, however, testified that he has not been advised of the lawsuit having been filed against him. To the contrary, he testified that he was made aware of the summons and complaint against him through a link shared with him online in August or September of 2019. Deposition Kyle Curtis, 14/22/15/23, ECF number 47.2. On January 23, 2020, having received no filing by Curtis's challenging either service, the entry of default, or plaintiff's motion for default judgment, the court entered a partial judgment by default, ECF number 17. On February 6th, this is like the recap episode. On February 6, 2020, Curtis filed his initial motion to set aside default judgment, ECF number 19. Curtis thereafter amended his motion and filed multiple affidavits and documents to support his contention that he was no longer residing with his mother at the Pleasant Garden address at the time of service, but was rather living in Charlotte, North Carolina with Benjamin Potts on July 28, 2020. Among other materials, Curtis filed his own affidavit, a document purporting to be an affidavit from Potts affirming that Curtis lived with him at the time of the summons and complaint were served, a lease bearing purported signatures of both Curtis and Potts by which Curtis was to pay Potts rent, a Discover bank statement from August and November 2019 purportedly mailed to Curtis at Potts's home address, affidavit Kyle Curtis, ECF number 31.1. I'm actually really happy to hear that my voice makes you sleepy. That's actually, thank you. I appreciate that. I hope people will put this on in the background when they're trying to sleep after all this is over. I should read more books. On September 9th, 2020, plaintiff filed an affidavit by Potts testifying that Curtis had forged Potts' signature on both the affidavit and lease Curtis had filed in support of his motion and testified that, in fact, Curtis did not live with Potts in Charlotte at the time of service and had not paid Potts rent, ECF number 38. Plaintiff also challenged the authenticity of the Discover bank statement Curtis submitted, in part by providing evidence that the address label had been falsified on the document Curtis submitted to the court, and the correct mailing address was Curtis's Pleasant Garden address at which service of the complaint and summons had been made. See Declaration of Megan Joyce, paragraph 3 to 13, ECF number 39, and Declaration of Megan Joyce at Exhibit A, ECF number 39.1, and Declaration of Megan Joyce at Exhibit B, ECF number 39.2. Curtis had contended, and Potts has denied, that Curtis made rental payments to Potts in July and August of 2019 through a Discover account. Plaintiff subpoenaed evidence from Discover, see DFS subpoena response, ECF number 47.40. That's one of the ones we couldn't look at because it was locked. In correspondence responding to plaintiff's counsel's inquiry as to why Discover's subpoena response included no statements prior to October 2019. Discover stated that, quote, the earliest statement information they could locate began on August 1st, 2019. The October 31st, 2019 statement shows a beginning balance of $0, which indicates there was no activity prior, and so no statements were generated prior to October 1st, 2019. DFS subpoena correspondence, ECF number 47.39. For anybody who doesn't really understand what that means, because it's kind of the way that was worded was kind of complicated, there was no bank statement prior to October. The account didn't exist. So if I don't know if you know how months work. I'm sure you guys do, but bear with me. January, February, March, April, May, June, July, August, October, November. So July and August, then October, meaning that if the Discover bank account did not exist until October, there's no way it could have been being used in July and August, because for those of you in the back, July and August come before October. Just to be clear. Because I know there's some people out there that are not the quickest, which is okay, it's fine. Having reviewed the contradicting sworn statements, the court advised counsel that it believed deposition of both Curtis and Potts should be taken. On October 22, 2020, transcripts of the deposition of Curtis, ECF number 47.2, and Potts, ECF number 47.1, together with multiple exhibits were filed. See notice filing ECF number 47. It's the one we read yesterday. Each continues to challenge the testimony of the other in material respects. Also September, yes. Also September, you are correct. At his deposition, Curtis repeatedly claimed that he could access his monthly statements through Discover's online portal and that he would produce statements documenting his rent payments to Potts. See deposition of Kyle Curtis, 31:7 to 16, 36:7 to 25, 39:1 to 10, 44:10 to 45:23. Curtis further testified that he had or would soon have additional materials to support his position, but that he would not identify or produce them at his deposition and would only privately provide them through his counsel, and then his counsel quit. He also committed to provide the original electronic copies of his earlier affidavits to address inconsistencies between them. To assure a complete record before ruling on the motion, the court ordered that Curtis could, on or before 5 p.m. November 5th, 2020, file the additional items he identified in his deposition. See order paragraph 12 to 13, ECF number 49, the one we just read. However, he has not filed any such material. You'd think that if you were looking for the truth of the matter, or if you were interviewing somebody, you would ask them why nothing was ever filed with the court when he said he had them. I mean, I did offer for, since Kyle said that he had no problem going on to talk to the opposition, I did offer that he could come and have a conversation with me and that he had no problem answering questions. So, I haven't heard from him. I don't know. Could it be he's just full of shit? I'll let you be the judge. Curtis's attorney defended Curtis at his deposition and conducted a complex examination of Potts at his deposition. Curtis's counsel filed a motion for leave of withdrawal after the depositions were complete, ECF number 45. The record does not reflect that Curtis provided his counsel any of the documents referenced at his deposition. The record is now complete and the motion is ripe for resolution. Standard of review. Rule 55D of the North Carolina Rules of Civil Procedure Rules provides that, quote, for good cause shown, the court may set aside an entry of default, and if a judgment by default has been entered, the judge may set it aside in accordance with Rule 60B, end quote. While the entry of a default judgment is subject to the discretion of the court, North Carolina law disfavors default judgment and advises that, quote, any doubt should be resolved in favor of allowing resolution on the merits of the case, end quote. London Leasing LLC versus Arcus 2015, NCBC Lexus 69 at *7, North Carolina Superior Court, June 29th, 2015. Emmerich versus Sunset Beach and Twin Lakes, Inc., 180, North Carolina, App 582, 590 to 91, 638, SE2D, 490, 496, 2006. Bracket, quote, a motion to set aside an entry of default is addressed to the sound discretion of the trial judge, end quote, and bracket, quote, default judgment is a drastic remedy which should be reserved for those cases, in which one party refuses or fails to attend his or her legal business, end quote. I mean, Kyle's definitely hasn't been avoiding and dodging his legal business, has he? Beard versus Pember, 68, North Carolina, App 5258, 313, SE2D, 853, 856, 1984. What constitutes good cause, quotes, For setting aside an entry of default judgment, quote, depends on the circumstances in a particular case and within the limits of discretion in an inadvertence which is not strictly excusable, may constitute good cause, particularly where the plaintiff can suffer no harm from a short delay involved in the default and grave injustice may be done to the defendant, end quote. Pebbles versus Moore, 48, North Carolina App 497, 504, 269, SE 2D 694, 698, 1980, citation and quotation omitted. Okay, if you guys want, okay, I'm going to give a little bit of an opinion here. I think the length of time that this court has taken has been harmful to the plaintiff in this case, though. So Steve, I think that this taking as long as it has caused Steve to incur more and unnecessary damage. In my opinion. Now, not everybody would think that, and I'm sure the court would probably have its own way of deciphering that, but just the fact that the Non Sequitur So channel is still up, it's still incurring money, and that money is still sitting there going to Kyle, probably, let alone the gamesmanship that's been going on, let alone the attempts at slander that people have tried to jump on this and try to use that, but that's my opinion. So, I don't know. You guys take that or leave it for what it is and come up with your own opinions. You don't need me to tell you. You guys can come up with your own. I'd like to know what you think. So if you want to leave a comment down below or message or send me a tweet or something, I don't know. You guys tell me what you think. An entry of default. Back to this. That's not with my opinion anymore. An entry of default is more easily set aside than a default judgment under Rule 60B, which, quote, generally involves a showing of excusable neglect and a... I don't know what this is. What is this? I don't know this word. I must find this new word. Boop. What are you?
Meritorious.
Oh, no. We had this word before. Meritorious. We saw this a couple times ago. Likely to succeed on the merits of the case. Meritorious. I didn't recognize it. Okay. Excusable neglect and a meritorious defense, end quote, ID citation omitted. Paragraph, I guess. I don't know what. When the trial court exercises its discretion in consideration a motion to set aside an entry of default, it is entirely proper for the court to give consideration to the fact that default judgments are not favored in the law. At the same time, however, it is also true that rules which require responsive pleadings within a limited time serve important social goals, and a party should not be permitted to flout them with impunity. No. The defendant here has certainly not been flaunting. No. Howell versus Halliburton, 22 North Carolina App 4042 205 SE 2D 617 619 1974. Analysis. Default motions, or defendant's, oh God. Defendant's motion rests on his contention that he was not living at the Pleasant Garden address at the time the summons and complaint were signed for by and delivered to his mother, Susan Curtis, as a result of which he was not served as required by Rule 4, defeating any claim that the court has personal jurisdiction over him. Plaintiff contends that valid Rule 4 service was effectuated. Quote, where a statute provides for service of summons or notice in progress of a cause by certain persons or by designated methods, the specified requirements must be complied with or there is no valid service, end quote. S. Lohman versus Ballard and Co. and 168 North Carolina NC 16 18 84 SE 21 22 1915. C. Williams versus Hartis, 18 North Carolina App 89 195 SE 2D 806 1973, Guthrie versus Ray, 293, North Carolina, 67, 69 to 70, 235, SE2D, 146, 148, 1977. Can you tell the last, not flaunting, sorry, my mistake, you're correct. Can you tell it's been a little while since I had to read, like, the citations off? I got used to them after a while, and then I've lost it. I lost it entirely. Rule 4J1A provides that service upon a natural person can be completed, quote, by delivering a copy of the summons and the complaint to the natural person or by leaving copies thereof at the defendant's dwelling house or usual place of abode with some person of suitable age and discretion then residing therein, end quote. Quote, where service of process had been, what a weird phrase, where service of process is had by leaving the summons and complaint with a person other than the named defendant, the substitute person must be a, quote, person of suitable age and discretion, end quote, who lives with defendant in his, quote, dwelling house or usual place of abode, end quote, and the summons must be left with the substitute person at their usual place of abode, end full quote. Guthrie, 293, North Carolina at 70, 235, SE2D at 148. If the summons and complaint were not served upon Curtis, as prescribed by Rule 4J1A, the entry of default and partial default judgment entered in this case against him are void and must be set aside. North State Finance Co. versus Leonard, 263, North Carolina 167, 139, SE2D 356, 1964. See also Guthrie, 293, North Carolina at 71, 235, SE2D at 149. However, when the plaintiff demonstrates legal service was made by an authorized manner, the law permits service. See Harrington versus Rice, 245, North Carolina 640, 642, 97, SE2D 239, 241, 1957. Oh my god, there's more. I suffer. The return receipt demonstrating proof of service by certified mail raises a presumption of valid service which can be rebutted, but is conclusive absent evidence in rebuttal. Grimsley versus Nelson, 342, North Carolina, 542, 545, 467, SE2D 92, 94, 1996. Bracket quote. Although a return of service showing service on its face constitutes prima facie evidence of service, such showing can be rebutted by the affidavits of more than one person showing unequivocally that proper service was not made upon the person of the defendant, end quote, and bracket. Quote, the service is deemed established unless, upon motion in the cause, the legal presumption is rebutted by evidence upon which a finding of non-service is properly based, end quote. Harrington, 245, North Carolina at 642, 97, SE2D at 241, quote, the burden is on defendant to rebut this presumption by clear and unequivocal evidence that consists of more than a single contradictory affidavit or the contradictory testimony of one witness, end quote. Gibby versus Lindsay, 149, North Carolina App 473, 560, SE2D 589, 592, 2002, citing Guthrie 293, North Carolina 71, 235, SE2D at 149. See also Harrington, 245, North Carolina 642, 97, SE2D at 241. Bracket noting that service of process should not be lightly set aside, and that overturning the presumption of service is not possible without clear and unequivocal evidence consisting of, quote, more than a single contradictory affidavit, end quote, end bracket. Whew. So, for anybody who got lost in all the quotations, this is saying that you need more than what Kyle provided to rebut the presumption of service, which was gotten via certified mail. Service is fine, essentially, and Kyle has failed to rebut it. Accordingly, plaintiff's service of the summons and complaint to defendant by certified mail to Pleasant Garden address and delivery to defendant's mother, Susan Curtis, at that address constitutes prima facie evidence of personal service. Thus, Curtis has the burden of presenting evidence in support of his challenge to personal jurisdiction. See Gibby 149 North Carolina App at 473 to 74, 560 SE2D at 592, bracket, holding that the defendant failed to rebut the presumption of service because the evidence he presented failed to establish clearly and unequivocally that defendant had assumed a new dwelling, house, or usual place of abode by date of service, and quote, end bracket. Womp, 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 womp. Intrigue Feline says, more than Kyle provided. No shit, he provided nothing since it was all forged. Look at all this evidence. It's fucking nothing. Is Kyle not gone to jail yet? Wonder if he'll get his $200 or just go directly to jail. Do not pass go. Do not collect $200. Well, perhaps we will find out on May 11th. 6 days away. That's when the hearing is, so... Hearing for civil contempt specifically, so that doesn't cover any criminal anything. That just the civil contempt. So not handing over the channel and its assets and whatever the financial shit. All right. Curtis's contention is that the Pleasant Garden address was not his dwelling, house, or usual place of abode on date of service, August 30th, 2019. There is no dispute that Susan Curtis is of suitable age or discretion residing at Pleasant Garden address, or that her signature on the return receipt is valid. I think there's some people, there isn't any question about that on the court right now, but I do know that there have been people that have compared the two signatures, the one on the electronic signature, the one on service, and then looked at the one on her affidavit, and people are speculating whether or not that was also forged, or one of them was forged. Right now it's not in the legal documentation, like nobody's provided to the court as an issue as of right now, but it's possible that it might come up later if there does end up being some kind of, like, when it gets to criminal stuff, things like perjury and forging documentation, if they end up looking at those signatures, then it might end up coming up there, but so far it is not in this litigation. North Carolina law provides no hard and fast definition of what is or is not a defendant's dwelling, house, or usual place of abode, but rather it is a question to be determined on the facts of the particular case, end quote, Van Buren versus Glasgow, 27, North Carolina App 217 SE 2D 579 582 1975, citation omitted. Thank you for omitting the citation, because frig's sakes, reading them all out every time is a lot. The court finds upon the current record that the greater weight of the evidence is that Curtis was residing with his mother at the Pleasant Garden address at the time she signed for the delivery of the summons and complaint, and that Curtis's testimony and evidence is not adequate or competent to support a contrary conclusion. Notwithstanding that Susan Curtis filed an affidavit stated when she signed the certified mail slip on August 30th, 2019, Curtis had resided in Charlotte since July 16th, 2019, ECF number 31.2, there is significant evidence to the contrary. Further, there is substantial evidence challenging Curtis's credibility. In fact, there is strong evidence suggesting that Curtis may have knowingly and intentionally submitted false testimony to the court. The court need not resolve that issue for purposes of ruling on this motion. The court need only determine whether Curtis has failed to provide sufficient credible evidence to overcome the presumption of valid service of the summons and complaint pursuant of Rule 4. So that's saying, like, listen, we don't have to address this and figure all this out to throw out your motion. So we'll deal with that later. We're going to focus on this for now. The court will separately consider whether a criminal reference or a further proceeding in the nature of criminal contempt may be appropriate. I'm not going to give you the spoilers of what they ended up kind of doing with that, but what the court allowed Steve to do when he refiled his contempt motion might hint a little bit at what the court may be thinking. First, Curtis does not rebut that he had, at least until June 2019, resided with his mother at her home at 1532 Providence Church Road, Pleasant Garden, North Carolina. Curtis has neither suggested nor offered evidence of any potential change of address other than establishing residency at the home of Benjamin Potts in Charlotte, North Carolina. Curtis's credibility when offering proof of establishing residency with Potts is in substantial question. Reasons include A. Potts has denied Curtis's assertion under oath with no apparent personal gain from having done so. B. Curtis admitted to altering an affidavit he filed with the court after it had been notarized to change the date of service through use of Adobe software. See Deposition Kyle Curtis 2822 through 3030. C. Plaintiff submitted evidence that suggests Curtis may have also modified Discover statements from their true original form before submitting them to the court, including that the address shown on the documents provided by Curtis vary from the address shown on the same documents as produced by Discover in its subpoena response. See DFS Subpoena Correspondence, DFS Subpoena Response, Declaration of Megan Joyce, paragraph 3 to 13, Exhibit A, Exhibit B, and D. Curtis testified that he had in his possession other documents consistent with this position, but has failed to provide them to plaintiff or file them with the court after being given opportunity to do so. Did I skip 34? I don't think I did. Did I by accident? The court concludes that... Oh, sorry, I think I did. The court concludes that Curtis has not shown credible evidence adequate to overcome presumption of valid service. My mistake. 34. Listen. Court says Q. 37. There is further evidence that would allow an inference that Curtis in fact knew of and or received the summons and complaint before default was entered. Service was made on Susan Curtis on August 30th, 2019. Potts testified that Curtis did not deny that Curtis was at the Pleasant Garden address the following day. August 31st, 2019, deposition of Benjamin Potts, 5410 and 5640, deposition of Kyle Curtis, 5360 and, I'm adding zeros to this, sorry, this is 54-1, 56-4, deposition of Kyle Curtis, 53-6 and 54-1, text message timeline ECF number 47.14. Yeah, this was redacted. Not redacted. This was sealed, but apparently Susan Curtis signed on August 30th. Kyle was like, yo, I don't live there though, but he was at his mom's place the next day. That is not that is rough. The evidence further suggests that the nature of pendency of the litigation was regularly and freely discussed by Curtis and others on forums connected to the YouTube channel that is subject of the litigation. See e.g. affidavits Stephen McRae, paragraph 7A, 7B, ECF number 22, deposition of Kyle Curtis, 45 to 25 and 47 to 8, or 47-8. Curtis admits that he was given a link to the court's electronic dockets in this case, which would have provided him access to all filings, including the summons complaint and affidavit submitting the return receipt confirming the delivery of the materials by certified mail to his mother at the Pleasant Garden address. Deposition of Kyle Curtis, 1422 and 1523. The testimony that, Curtis spent significant periods of time at Potts' house in Charlotte during July, August, and September of 2019. He spent just as much, if not more, time at Pleasant Garden address during that same period, including from August 31st through September 5th. Deposition of Benjamin Potts, 55-2 to 6, text message timeline. Big oof. The court's observation in Van Buren versus Glasgow is apt. paragraph. Indeed, because of his family's continued occupancy in the North Carolina home and because of his regular and frequent return hereto, it would appear that appellant had a closer and more enduring connection with the North Carolina residence than he had with the South Carolina house. Certainly, when all of the circumstances are considered, his relationship and connection with the North Carolina dwelling were such that there was a reasonable probability that substitute service of process at that dwelling would, as it is in fact here, did inform him of the proceedings against him in apt time to permit him to assert in a timely fashion such defense as he might have. 27 North Carolina Apt at 6-217 SE 2D at 582, overruled on other grounds in Love v. Moore 305 North Carolina 575-91 SE 2D 141 1982. The court finds that the evidence presented supports the conclusion that the Pleasant Garden address where the summons and complaint were served was Curtis's, quote, dwelling house or usual place of abode, end quote, for purposes of Rule 4 at the time of service on August 30th, 2019. I'm curious to know if the lawyer or firm that he hired continued to follow the case after withdrawing. Like, I'm curious to see if they were just like, I wonder how this is going to go for that guy. The court finds abundant evidence that Curtis was aware of the lawsuit and the nature of the allegations against him significantly before default was entered and certainly before partial judgment by default was entered. Our Court of Appeals commented that the drastic remedy of default might be best reserved for cases where defendant, quote, refuses or fails to attend to his or her legal business, end quote, Beard 68, North Carolina App at 58-313 SE2D at 857, but this appears to be precisely such a case. The court concludes, this is the big part, the court concludes that Curtis has not demonstrated an adequate basis to overcome the presumption of valid service of the summons and complaint upon him by leaving them with his mother, Susan Curtis, who signed for the receipt. The court concludes that both the entry of default and the partial judgment by default were properly entered against Curtis, over whom the court had obtained personal jurisdiction through valid service. Conclusion. For these reasons, defendant Kyle Russell Curtis' amended motion to set aside entry of default and partial default judgment is denied. It is so ordered the 20th day of November 2020. So the court decided that there is a very strong likelihood that Kyle faked documents and that he was in fact served properly and that his motion of default to set aside was denied, meaning that all of those things, at least until the 20th day of November 2020, if not from the initial judgment, is in full effect. And according to what the judge said in the hearing on the motion to set aside, so before the deposition, said that until a decision is made, that judgment is still in full effect, meaning that it is now, what is the date? It is now May 5th, 2021. This default and partial default has been in effect the whole time. Chesh is so used to the internet that she instinctively avoided 34 because it's not safe for YouTube. Thanks, Helios. Thanks for covering for me, man. All right. Last court notice. Let's see what the court has to say. State of North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant, in the General Court of Justice, Superior Court Division 19 CVS 8163, order granting leave to withdraw as counsel. This matter is before the court on the motion of Ellison Winters, LLP, and its attorney, Scotty Forbes Lee, to leave to withdraw as counsel for defendant Kyle Russell Curtis. The motion, ECF number 45. Ellison Winters filed this motion pursuant of Rule 16 of the General Rules of Practice for Superior Court and District Courts and Rule 1.16b of the Rules of Professional Conduct. For a good cause shown, the court concludes that the motion should be allowed. It is therefore ordered that the motion of Ellis and Winters LLP and its attorney Scotty Forbes Lee for leave to withdraw as counsel for defendant is granted. It is further ordered that Miss Lee is to advise defendant of this order as well as the order on amended motion to set aside ECF number 50 and to file a statement with the court confirming she has done so. Ellis and Winters LLP and Miss Lee are hereby relieved of further responsibilities as counsel in connection with the above captioned matter. There are other pending motions in this case, including a motion of the court order defendant to show cause as to why he should not be held in contempt. The court will defer its further consideration of motions in this matter pending an opportunity for Mr. Curtis to secure other counsel. He has not done so, as far as no new lawyer has filed since this. The court directs that should Mr. Curtis so choose, a new counsel shall file the appropriate notice of appearance on or before December 2nd, 2020. It's so ordered the 20th day of November 2020. Then we've got this other notice from Kyle's lawyer who was withdrawing. State of North Carolina. Oh, also my mom is in the chat. Hello, Mom. Everybody say hi to my mom. State of North Carolina, Guilford County, Stephen McCrae plaintiff versus Kyle Russell Curtis defendant in the General Court of Justice, Superior Court Division 19 CVS 8163. Notice of compliance with order granting leave to withdraw as counsel, ECF number 51. Pursuant to paragraph 3 of the court order granting leave to withdraw as counsel, ECF number 51, the undersigned confirms that she advised defendant Kyle Russell Curtis of the order granting leave to withdraw as counsel, ECF number 51, and the order on amended motion to set aside, ECF number 50. Copies of both orders have been sent to Mr. Curtis by mail and by email. This is the 20th day of November 2020. They did that the same day. Damn. Ellis Winters LLP. Certificate of service. Huzzah. Court order. This was now in February 2nd of 2021. So some time has passed. State of North Carolina, Guilford County, Stephen McCrae plaintiff versus Kyle Russell Curtis defendant in the General Court of Justice, Superior Court Division 19 CVS 8163. Order. The court entered a partial judgment by default on January 23rd, 2020, ECF number 17. Defendant Kyle Curtis filed his motion to set aside default judgment on February 6th, 2020, ECF number 19, and on July 28th filed his amended motion to set aside entry of default and partial default judgment, ECF number 30. After hearing oral argument and considering all matters of record, the court denied the request to set aside the default judgment. That default judgment remains in full force and effect. On February 12th, 2020, plaintiff Stephen McCrae filed a motion requesting the court issue an order directing Curtis to appear and show cause why he should not be held in contempt for failing to abide by the court's judgment. PL, that's PLS motion. Plaintiffs. PL is plaintiffs. I figured it out. Plaintiff's motion order to show cause, ECF number 23. The court issued its order on motion for order to show cause on April 13th, 2020, ECF number 26, which provided that emergency orders entered by the Chief Justice of the North Carolina Supreme Court in response to COVID pandemic, then in force, provided that Curtis should not be required at that time to respond to McCrae's motion and could not be compelled to appear in court in person to show cause why he should not be held in contempt. Those administrative orders have expired. The court is not currently advised whether Curtis has now complied with the default judgment in whole or part, and whether it is necessary to consider further whether Curtis should be required to demonstrate why he should not be held in contempt for his failure to comply. Basically, they're saying that was a year ago. We need a status update. The court orders as follows. McCrae shall, within 10 days of this order, file a status report as to the extent to which Curtis has complied or failed to comply with the default judgment. If appropriate, amend his motion to show cause in light of subsequent events. The court will then determine whether to order that Curtis appear to show cause why he should not be held in civil contempt, criminal contempt, or both. So you remember a couple minutes ago when I said that if the court said, hey, we can talk later about criminal contempt and we'll see what we say at that point. this may or may not be a hint that the court may be giving to be like criminal contempt, though. I don't know. Maybe that's just me reading between the lines. This order shall be posted on the court's electronic docket, shall be mailed by certified mail, return receipt request to Curtis at the last address identified in the filings with the court, and shall be emailed to Curtis at the email address from which he has corresponded with the court, which is the Pleasant Garden address, by the way. Either McCrae, Curtis, or counsel shall advise the court of any known change from the above in the address at which Curtis can be expected to receive communications from the court. So, for those of you who watched Clowntown from the other day, I definitely advise you catch up with it, because it's pretty interesting. Kyle said he moved, but has not updated his address with the court as of the time of that video. It is so ordered the 2nd day of February 2021. And then we got a status report from Steve, so we will do 54 next time. Oh boy. Oh boy, there are 6 days left to the hearing. This countdown has got to be one of like the most entertaining things I've seen in a while. The court was like, hey, the way I'm reading this is the court just said, hey Steve, add contempt to your filing to show cause. Cool, thanks. Now, the hearing that is coming up is not for criminal contempt, because tomorrow we'll talk about what Steve did end up filing, about whether he filed for contempt or he ended up, spoilers, he ended up filing for contempt, for criminal contempt and for civil contempt. So the hearing that's coming up on May 11th is for civil contempt only. It is not for the criminal contempt yet. That will have to come later. So the fun thing about this is that there's a few options, one of them being that Kyle doesn't comply, goes to jail, tries to comply, Steve has the channel backed, the criminal contempt then goes through, and he has to fight the criminal contempt from jail or prison, whichever one. I'm not sure. I think it's jail first, then prison. America's weird. I don't know. But, oh boy, I'm holding out for those tickets to Mexico. I'm holding out. The fact that he's just like, no, I live somewhere else now, but didn't do anything with the court. Anyway, he didn't rebut service. Service was presumed. And the court's like, yo, you fucking lied, bro. So, we'll have to see where this goes. Don't forget to boop the subscribe button. It's not a subscribe button. It is still a subscribe button, isn't it? Yeah, boop the subscribe button, because you can't just touch it lightly. You can't smash it. Literally can't. Give that a boop. Give the likes a boop. Give the share a boop. Leave me a comment that just says boop. And I'm gonna go boop my dog. I'll see you guys next time. Have a good day. See you tomorrow for more. Bye.